KAVEH, all persons of any duty before the Honorable Justice in Appeals Court, now sitting in Boston, far within the Commonwealth, draw near, take your attendance, you shall be heard. God save the Commonwealth of Massachusetts, this court is now open, please be seated. Morning,
Morning.
Good morning, Your Honor. Good morning, sorry. Everyone here. Good morning, good morning. Welcome to the Appeals Court. My name is Peter Sachs. To my right, your left is Justice John Englander. To my left, your right is Justice Marguerite Grant. Will be your panel this morning. If you've been in the Appeals Court before, you know we've read the briefs, we've read the record, we know what your arguments are, we know the facts, so please just jump right in to the most important part of your arguments, because 15 minutes per side goes pretty quickly. With that, I'll call the first case, first and only case, 23P 1168, AFRASIABI versus Harvard University. Mr. Keefe.
Good morning, Your Honors. And for the record, my name is William Keefe, appearing on behalf of Dr. AFRASIABI. His primary argument is that the Superior Court judge got wrong the finding that Harvard's communication with the FBI was legitimate petition activity. It was not. A proper petition activity by Harvard under these circumstances would have been identifying an employee or employees at Harvard who claimed that they were the victim of criminal harassment by Dr. AFRASIABI, and the proper petitioning activity would have been to go to the Cambridge Police Department or the Harvard Police.
Why wasn't it proper petitioning activity to say, hey, we have documents that appear to be subject to a protective order from some case involving the Department of Justice, and we need to tell you about that? Why wouldn't that be proper petitioning activity?
Because that I don't believe is what happened, and that was not before Judge Belizos in the Superior Court. We're talking about a letter from Senator John Kerry that Dr. AFRASIABI
I don't think that's what we're talking about at all. Unfortunately, we don't know exactly what we're talking about, but we've got a record from DOJ that says we got a letter from Harvard, or we got contacted by Harvard, and Harvard sent us a bunch of documents. Harvard sent us, the FBI actually, a bunch of documents that were subject to a protective order in a case that we're handling. And we have a problem with that because that's a violation of the protective order, and we're sending you a notice about that.
And I think the loan document at issue was that letter from Dr. Kerry.
Why do you think that? That's not at all what I read from the letter that's in the record from the Department of Justice.
It's attached to the complaint.
Yeah, because the thrust of what Harvard communicated with the Federal Bureau of Investigation was a claim that Harvard employees were being harassed.
Is it harassment to send somebody documents that are subject to a protective order in an unrelated case?
No, not at all. Criminal harassment requires
It
other elements.
Must it be criminal harassment in order for Harvard's letter to count as petitioning activity? Can't it just be harassment in the colloquial sense of the word? He's sending us, our people, something that looks like it's subject to a protective order, and as Mr. AFRASIABI said in his complaint, Harvard was trying to lean on the U.S. government to do something about it.
Yeah, so no, I think that if you're going to communicate with the FBI claiming harassment, there has to be some legitimate request for a criminal investigation.
That's the only reason to petition the FBI?
No, but that's what happened here. They were claiming harassment, and there is no comparable federal crime that the FBI could investigate under the United States Code. So,
how do you know they were claiming harassment?
That was what was presented before Judge Belizos.
Well, you know, I don't have the document or anything that was sent to the DOJ.
Well,
What we have is the DOJ's letter, which says to report that you sent harassing emails. Now, we don't know whether the word harassing, which is, that word, by the way, there would be no complaint and no case whatsoever if that word did not appear in the DOJ's letter, right?
Correct. but-
Okay. We don't know who used that word. We don't know whether it was used by Harvard or whether it was the DOJ's own characterization of what Harvard told them.
Nor did Judge Belizos, the defendant in the proceeding.
Why hang so much on why hang so much on that word? Why hang, well, there's a question why one would hang a complaint on that word, but why are you, or why should we hang that much on that word?
What happened here to Dr. AFRASIABI, and what he claimed before the Superior Court judge, was that Harvard was not petitioning legitimately. They were trying to, they made false statements to the FBI in an effort to influence the criminal proceeding that he was the defendant in.
What was the false statement that you say Harvard made?
That Harvard employees.
These people were being harassed.
Yes, that's the false
So
statement.
we're back to that same word that we don't even know if Harvard used.
And again, Judge Belizos, my client requested that some limited discovery be allowed so that the record could be complete, and that's what Judge.
Fair enough, I understand that point.
That's what the Superior Court judge should have done.
But the rabbit in the hat in your argument is when you say legitimate before the word petitioning activity. Because as I read the definition of petitioning activity in the statute itself, and as I understand petitioning activity for purposes of the First Amendment to the United States Constitution, if I write a letter to the FBI, or if I call the FBI and I say, hey, we just got a whole bunch of documents that say subject to protective order, and we thought you ought to know that. Why isn't that petitioning the government?
Because I don't think that that's what actually happened here. And again, there's this dearth of facts that were presented to the.
I don't think that's what actually happened.
Because what Dr. AFRASIABI had the court allowed some limited discovery, would have shown that he was the subject of this indictment in the United States District Court in the Eastern District in Brooklyn, New York. It was a case that gained international attention. Harvard knew about it, and what Harvard set out to do is they have a long history together. Harvard does not like him. He has brought many.
So you're arguing that there's subjective motivation in contacting the Department of Justice.
In an effort to improperly influence that criminal case down in New York.
What do you do with the Massachusetts cases that say the only question is objective for purposes of the Anti-SLAPP Act? It's not, the subjective motivation of the person petitioning the government is not relevant, right? Isn't that what the cases say, Harrison?
That is what the cases say, but I think what happened here to Dr. AFRASIABI is very different from that line of cases, and where Harvard had discovery been allowed, Dr. AFRASIABI would have been able to show that Harvard's intent here was to undermine his criminal case, to influence the prosecutors and the judge. This information was presented to his.
But the March 3rd letter says we're not going to do anything about the fact that you've given out the documents. We're not going to ask for them back. So where does that lead you?
I didn't get that last part, Your Honor.
The March 3rd letter from the Assistant U.S. Attorneys says, we understand you've sent these documents in violation of the protective order. We're not going to ask for the documents back at this point. So it doesn't look as though Harvard did influence the U.S. Attorney's Office into doing anything.
But they certainly tried, and what Dr. AFRASIABI's view of this is, Harvard was trying to lock him up, have his.
If somebody called the FBI or any police department and reported a crime, and in the course of reporting that crime, said something insulting or untrue, let's say insulting and untrue, about the person who they allegedly committed the crime, would that make their report of the crime not petitioning activity?
No, I don't think so. And that's a good point.
So what's the difference?
Your Honor, the difference here, again, is Harvard's intent to, as Dr. AFRASIABI, had he been given the opportunity to obtain some discovery. Harvard, again, they have a long history with him. Harvard is not your average citizen calling 911.
You're arguing for an exception then, as I hear it. How would you articulate the standard you want us to apply in order to allow this case to go forward despite the Anti-SLAPP Act? Because the motivation was to what?
I think the court should be in a position to be allowed to conduct some kind of inquiry of a defendant in assessing these anti-SLAPP special motions to dismiss, because there are invariably going to be circumstances, and I know the Corbin versus Gastfriend case is not similar factually, but there the court did an extensive inquiry about a physician who was submitting affidavits in a board of registration of medicine proceeding against the plaintiff in that case. So there should be something carved out for the Superior Court judge to allow for some limited inquiry to determine.
So, didn't the Supreme Judicial Court in the recent Bristol asphalt case decide essentially that the subjective motivation of the moving party in the anti-SLAPP motion, which would be Harvard in this case, is not relevant to whether the special motion should be allowed?
Yeah, no, I'm aware of that, and that case factually is very different, and again...
Sure, factually very different, but the principle, I think it was part of the Blanchard case, so-called second path to defeating a special motion to dismiss, but the SJC has now said we don't follow that anymore. We don't look at whether there was this suit was primarily intent to chill.
Yeah, no, I don't think that those courts were presented with a petitioner who was not proceeding with clean hands. Harvard...
But isn't that exactly what they were arguing in Bristol Asphalt, that this other company is powerful and big and they're just throwing their weight around to prevent me from getting what I want?
There was no element that the petitioner was making false statements with the intent to harm the plaintiff, and certainly no situation like here where, again, Dr. AFRASIABI claims that Harvard was trying to improperly influence.
But so then what do we do if, with the sentence in Bristol Asphalt at page 563, neither a special motion proponent's identity nor the motive behind its decision to engage in petitioning activity or to file a special motion to dismiss is relevant to the threshold inquiry? Should we just write a case saying, well, but Harvard is different because it's Harvard, not Bristol Asphalt or Rochester Bituminous? I'm not sure which one.
I guess once the party has met that threshold showing, the second step is whether the plaintiff can demonstrate whether it's a sham petition. And I think had the Superior Court judge here, again, allowed some further limited discovery, Dr. AFRASIABI would have been in a position to make that showing that it was a sham petition.
If an attorney receives documents that they have reason to believe were wrongly sent to them, does the attorney have an obligation to contact either the sender or the rightful owner of those documents and disclose that they've received them?
Yeah, I'm not sure the answer to that question, but I do know that Judge Belizos was never presented with any of the documents that Harvard, the communications that Harvard made to the Federal Bureau of Investigation. And I think the only thing presented to the judge was the email from the Assistant U.S. Attorney.
So what's this in this? We have before us Record Appendix 3 sealed. It's pleading number 15, and there's 20 pages that are labeled at the bottom, subject to protective order, with Bates stamp numbers, and there's various things in there. How do those get into the record?
I think they were presented by my client. My client was the one who is the only one who tried to prevent Judge Belizos with what I think were the supposed.
I think that's true, counsel, what you're saying. But we have the record. What is in the record is what the Department of Justice says was sent to the FBI. And what they say is that they're documents that were subject to protective order with our Bates numbers on them. I mean, you know, if I'm sitting at Harvard as a counsel and somebody drops on my desk a bunch of documents that say subject to protective order with Bates numbers on them, that's like dropping a great big pile on my desk. I got to do something about that because I'm now apparently in possession of something I shouldn't have. So what they did is they sent a letter they called the FBI. They said, hey, looks like we got something we shouldn't have. Isn't that what happened?
We don't know because Judge Belizos wrongfully expedited his conclusions and decision. So thank you, Your Honors.
Thank you, Mr. Keefe.
For the cases, and in fact seems to want to create a kind of Harvard-specific exception.
He's not saying it's Harvard-specific. He's saying, hey, the purpose behind this was to influence a criminal case that I was involved in. And
So-
I should be able to get some discovery to find out if that was in fact the purpose, because that doesn't seem very consistent with petitioning activity. Isn't that what he's saying?
That's part of what he's saying, but I think, Your Honor, the court has been clear with the cases that you cited and that are in the briefs that the subjective motive behind the petitioning activity, both before and even more after Bristol Asphalt, are not pertinent. Even during the sort of Blanchard era, those questions were not pertinent during the first phase of inquiry about is this petitioning activity. The subjective motive is not relevant. So that's.
Okay, but could the subjective motive bear on objective reasonableness of the conduct?
Well, I'm not sure objective reasonableness of the conduct is even a consideration here.
Well, of course it is. That's what sham is.
Well, but I think that the sham language was really more part of the Blanchard definition than it is in
No, the test is it based solely on petitioning activity? If it is, the case can still go forward if it is objectively without reasonable basis in fact or law.
Right, reasonable basis in fact or law, and I think the motive does not bear on whether there's reasonable basis in fact or law. I mean, I suppose in some extreme case it could.
Right, well that's exactly my question, counsel.
I don't think that's this
exactly
case.
what I mean. Okay,
so
that I think is what your brother is arguing.
But so here what we have, first of all, the complaint itself and written documents from AFRASIABI that were then added to the record via affidavit make clear that he has been sending unsolicited communications voluminously, hundreds of them, over the course of decades to Harvard. And so whatever may have been attached to these particular communications, it is not objectively unreasonable. It is in fact objectively reasonable for Harvard in the colloquial to describe these communications as harassing. They are unwanted communications.
Are you conceding that they did that? Are you conceding that Harvard used the word harassing?
I'm not conceding that Harvard used the word harassing, and Your Honor is right that the record is not clear about that. It might even have been DOJ's classification, but what I'm saying is, even assuming for the sake of argument that Harvard used that word, which is essentially the position plaintiff wants to take, it doesn't matter because it's objectively reasonable. Unwanted communications over the course of decades, colloquial description of what that means.
But the unwanted over the course of decades involving, I think you said thousands of communications, is that in the record?
Yes. The complaint itself acknowledges on pages 25 and 26 that he made, I want to make sure I get the exact language here, let's see. It's a combination of two things. There's language in the complaint that says since 1996 he's been sending complaints over and over to Harvard. Then he sent a communication during the process of the litigation, which got put into the record via affidavit and is quoted in Harvard's memorandum in support of the motion to dismiss, where he acknowledges sending hundreds of. He actually, defines that as hundreds. He adds an actual number to the many communications over decades. That's added to the record by AFRASIABI himself. The district court decision cites that, and it's in the papers. I don't have the page number at my fingertips right now. So I think that we have as an established fact, both as alleged in the complaint and as added to the record by admissions AFRASIABI made himself during the litigation. So in that sense, as a colloquial description, even if it was in fact Harvard that said, we're getting harassing communications from this guy, there's nothing objectively unreasonable about that. And by the way, the other piece of the test under Bristol Asphalt and Duracraft before it that has never been met here is that the plaintiff has to show actual injury caused by the statement. In the papers, in the trial court's decision, we argued, the trial court agreed, there has been no showing of actual injury here. The only thing that happened is the U.S. attorney wrote a warning letter saying, hey, when Harvard told us, whatever it was they told us, we got these documents attached to them, and you're violating the protective order. He doesn't allege any harm came from that. There's no action was taken in the criminal case as a result of that. And so even if we put aside the sort of what the plaintiff wants to do with the standard under Bristol Asphalt, the actual injury prong has not been met here. There's no dispute about that. There's
reputational harm, doesn't he allege that in the complaint?
Well, but he alleges that in a vague way, which under the case, under the cases as cited in the briefs and in the district court or the trial court's decision, sort of a vague allegation of reputational harm is insufficient to show actual harm as required under the anti-SLAPP statute. And here, it's hard even to imagine, even if he had sort of tried to.
So if he shows that the behavior in petitioning was objectively unreasonable without basis in fact and law, and he says, and my reputation was harmed, it's still dismissed under the anti-SLAPP statute, even though the harm itself might be provable as defamation damages?
As a matter of pleading, there has to be more flesh on the bare allegation of reputational harm, some kind of economic loss, some kind of job loss, something. Here, all you have, and he doesn't even try to make this argument,
that
right?
comes from what case?
That is, one moment.
That it has to be economic or job loss, that reputational harm is not enough.
I don't know that the case goes on to say it actually has to be reputational or job loss, but there's I want to find the.
Well, that's what.
Well, I'm trying to.
Because it seems, I don't doubt that it's possible that that's what they've written, but it seems kind of odd law to me that somehow a defamation claim is for reputational harm has been written out. Well, it's because of the way we construe the anti-SLAPP statute. It's
a different question. Like what reputational harm, as a matter of pleading, would make a defamation claim survive, versus what level of harm is necessary to survive an anti-SLAPP motion to dismiss. But I hear what you're saying. But what I'm saying is that doesn't make a lot of sense to me, because what you're arguing is that the case must be dismissed under the anti-SLAPP laws, even though it otherwise could go forward as a defamation claim based on the damages that were alleged. Do you follow me? I follow you, but I think the statute itself and the case in the briefs that I don't have at my fingertips, but is cited and is also mentioned in the trial court's opinion.
The Driscoll case? Driscoll versus Board of Trustees of Milton Academy?
I'm actually off the top of my head not recalling, but there was a case, and it actually might have only been a superior court case. I'm not sure there is any appellate court law on the question. But it's a sort of separate basis on which, just as a matter of defective pleading, this case could still be dismissed under the anti-SLAPP statute. But I think we're getting a little bit far afield from the objective reasonableness.
I don't know if we are. I think you're making an alternative argument, and I was exploring it.
Yeah. I don't think the court has to get there, though, because I think the objective reasonableness here is well established, and the law saying that the subjective motive is not relevant is also, I think, it's sort of the cases are replete with that language.
I wanted to ask about the use of the term unwanted, which Harvard uses extensively in its brief, and I believe the judge relied on in part in his decision, even though Mr. AFRASIABI sought to withdraw that allegation of his complaint through, I think it was a motion to cure.
Right, so what AFRASIABI proposed was to say, to add allegedly unwanted to unwanted, which was in his original pleading. I think the reason why that would be a sort of futile amendment is that, you know, even if there hadn't been the initial quote-unquote admission that the communications were unwanted, it would still, even if there had not been that admission, it would still be objectively reasonable for Harvard to say, this guy's been sending us hundreds of complaints to all kinds of staff members over 3 decades, and that, you know, as a colloquial matter, we're going to call that harassment. That's not an unreasonable thing to say, even if AFRASIABI tried to insist, oh, I think they really wanted to get these emails. You know, he could allege that, but I think that would not change the objective reasonableness of what Harvard, for the sake of argument, will assume the way Harvard described the communications to the FBI. I mean, look, this is an extremely thin thread on which to bring a defamation case in the first instance, right? It's this third-party characterization of something Harvard said using the colloquial term harassing. It was not an allegation of a specific violation of a specific crime. And so, and you know, to turn that around, along with the revelation that protective order material was being improperly sent to Harvard, and then try to use that into a weapon to revive 30-year-old grievances against Harvard, I mean, that's really quite an abuse of the process, and precisely the kind of thing I would suggest the anti-SLAPP statute was designed to eliminate.
Based on the record before us, including, I suppose, the March 3rd letter, what can we infer was the redress that Harvard was seeking from the FBI?
Well, first of all, I think the plaintiff is wrong, a plaintiff appellant is incorrect in the briefs to suggest there has to be a definitive or sort of defined specific request for redress. Both the statute and the cases interpreting the statute just say, you know, communication with a government authority to inform them, you know, to somehow let them know about an issue or a problem, even without a request, that is sufficient. So there doesn't have to be a specific request, and in fact there may not have been here, we don't know, but I think it is absolutely reasonable to infer from the record that we have, which I think the court has already made that inference in a lot of its questions, and it's very clear just from the writing that the U.S. Attorney sent that you know, Harvard had a concern perhaps not just because they were getting more of these harassing emails, but because there were these protective order documents attached to it.
Yeah, and the problem with that from your perspective is that the documents that were sent to Harvard were all documents that the plaintiff would have possession of because he had sent them in the first place.
Well, I mean, it's not clear, first of all, if the plaintiff had all the documents in his possession, because the sealed submission that he
or certainly he had seen them.
He may have seen them, but it's not clear that he had possession of them or remembered them or had them in any form other than having received them from the Department of Justice. We also don't know because, I mean, this record wasn't developed because I would submit.
Harvard gets a bunch of documents that say subject to protective order, but they decide they want to tell the FBI about that. But the documents that they got that they want to tell the FBI about, it's hardly the case that those documents were not known to AFRASIABI.
It's not at all clear if the actual letter from John Kerry to DOJ from 2010 was necessarily known to AFRASIABI. Certainly his letters to Kerry's office, you know, with the one-sided description of what he claims to have experienced, asking for the senator's intervention, he would have known about. But at the end of the day, it's about the reasonableness of what Harvard did, right? And if a lawyer, if a university administrator gets documents that say protective order on them, it's well known that this individual is under federal indictment in New York. It's absolutely reasonable. It might in fact be an obligation, as Justice Grant suggested, unless there's some client confidentiality reason not to raise the issue. It may in fact even be an obligation for that person to say, to go back to the owner and say, you know, what are these? We have them. Is that a problem? And so, you know, that's sort of another. All the reasonable inferences that one can draw from the bare sentences in the U.S. Attorney's letter all support a conclusion, a really inescapable conclusion, that what Harvard did here was objectively reasonable. You know, and on the colloquial harassment point again, I think it's also sort of interesting, maybe even ironic, that like even the SJC in the Benoit v. Fredrickson case, one of the core cases about communications with law enforcement being protected petitioning activity, the part of that case was about whether you can do an interlocutory appeal of a denial of a special motion to dismiss. The court concludes yes, and why do they explain? It's because one of the purposes of the anti-SLAPP statute is to avoid the, quote, harassment of litigation, right? Even the SJC understands and used the word in that case in a colloquial manner. No one is suggesting that filing, you know, that filing a lawsuit or litigating a lawsuit is harassment in some criminal way, but it can be harassing to the party that has to pour resources, time, and money into defending it. And so, you know, harassment can take many forms. Nobody was suggesting, there's no suggestion here that Harvard was making a straightforward allegation that this man is committing criminal harassment, you should go do something about it. It's a gerund. It's describing communications as harassing, which is objectively reasonable. Mr. Keefe also argued that, you know, there was no crime the FBI could investigate on that, and that's absolutely not the case. I mean, the FBI investigates and the U.S. Attorney prosecutes cyber-stalking crimes all the time. I'm not suggesting that this particular case necessarily rose to the level of cyber-stalking, but sending unwanted emails repetitively to an individual who does not want them can, in appropriate circumstances, be prosecuted under federal law as cyberstalking. So it's not like this is something wholly, you know, unknown or something the FBI would never conceivably deal with. And so, you know, simply put, it's sort of an unusual factual circumstance, certainly, but if ever there were a situation where the anti-SLAPP statute is an appropriate means to prevent a sort of vexatious litigant from finding yet another reason to sue a party, I would suggest this is one of those situations.
All right, seeing no further questions, thank you both for your arguments, and we'll take the case under advisement, and we're adjourned.
Thanks to both of you.
Thank you.
For coming in.